All right, so we are live. Welcome everyone to another episode of Positively Family Law. Sorry for a little delay there, but we are back talking about marital assets, which is always a fun topic. So I guess the first, just starting off the bat, what is considered marital assets?
So within Massachusetts, because our firm practices solely in Massachusetts and Rhode Island, so what I'm talking about right now is solely Massachusetts, to be clear, because there are a little bit of a difference between Mass and Rhode Island as well. And if we start getting into other states, not licensed there, so not applicable whatsoever. So Massachusetts only. Marital property, marital assets within Massachusetts is basically anything that is owned by the couple, whether individually, whether jointly, at any point in time, is going to be considered a marital asset. Unless you have a prenup that specifically categorizes property as individual property, pretty much everything you have, whether it's debt, whether it's an asset, whether, regardless of what it is, it's going to be considered marital property or marital asset that needs to be discussed as to how to divide it. So if you think about it, if you have a great big cooking pot, when you come into the marriage, maybe you come in with some property, you come in with a retirement account, you come in with a house, you might come in with an inheritance. If you don't have a prenup, then essentially, even if those things happened prior to your marriage, they all get thrown in the pot. So then anything that is acquired during the marriage, whether you rack up $75,000 worth of credit card debt, whether you buy a yacht, whether you have a vacation home, all those things also go in the pot. So then within the divorce, what happens is the attorneys, or if you can't agree, eventually the judge reaches into the pot and says, okay, here's the things that we need to divide. Here's how we're going to divide them up. So maybe this house goes over in spouse A's category. This house goes over in spouse B's category. And then that's what happens. And so that's kind of when you talk about marital assets in relation to a divorce, you're talking about absolutely everything. I just knocked over my water.
Okay. So I guess the biggest question, and you could probably clarify a little bit better, but the biggest question I have in regards to assets is like, oh, okay, I'm getting divorced. Now I have to give up everything. Now I have to give up everything. It's going to be divided in the middle, and that's it. Each person's going to get half. That's not always the case, especially in Massachusetts, correct?
Correct. Not always, usually. So there's a big difference between, black and white, this is how it gets divided, versus equitable distribution, which is what Massachusetts abides by. So equitable distribution, although generally, especially in long-term marriages, would be looked at as a 50-50 division. In some cases, and this is why it's important to really know where your case might fall, equitable doesn't mean equal, it means fair. So there might be a reason why one person should get a greater share of the assets over the other person. And there's a ton of different factors that go into why that should happen and when. For the most part, if you're talking about getting a divorce, you are more than likely looking at a 50-50 division, but there are cases where that's not appropriate.
Okay. And so, when you say equitable division, obviously, can you give some examples of that?
Sure. So let's say I love getting married to you during our Zooms. So let's say we get married, but we walk in and you've been pretty established. So you have a $500,000 in your 401k. You have a $750,000 house. So we get married and I walk in with my dog, Fluffy, and that's all I've got is my dog, Fluffy, and I'm walking into your lifestyle. So if we've been married a short period of time, so let's say, 6 months go by, a year goes by, and you're like, Heather, get out of here. And so now we're divorcing. I would be deeply hurt, but you would have reasons, even if we didn't sign a prenup, to say that even though your property, your $500,000 in your retirement, your $750,000 house, even those would be considered marital property and in the pot, you'd have a really solid argument why the majority of that should come out and be on your side and less of it be on my side. Now, contradicting that, there might be arguments that maybe then I get a really kick-ass job and I'm contributing to the house and I'm putting work in the house. And that means that maybe I get more than zero, but still, even in that situation, probably not 50%. So that would be kind of an example that I'd use to show when an equitable division is different than an equal division.
Okay. So now, kind of going into that, what about if you've been married for like 20 years, but I'm still the person who brought in all the money and you stayed at home with Fluffy all the time for 20 years?
Well, again, this is where there's a lot of gray area. Maybe I stay home with Fluffy, but I give you so much enjoyment and I cook all your meals and I clean the house. So that would be a factor that the court would look at. The longer the marriage, the more likely it is that there's going to be a 50-50 division. So once you start getting into 10, 15, 20 years, more than likely the court, if there's not an agreement otherwise, the court would look at that and say, there had to have been some mutual benefit here to allow this to continue. But again, that doesn't necessarily mean it's going to be 50-50. It might be, let's say I just have, I love to go shopping. And so I'm not working because I'm taking care of Fluffy and you're out, busting your ass. You might have an argument why, if I'm not actually contributing and everything that I'm doing is really, my closet's kick ass, I've got crazy shoes, but I haven't contributed, you might have a really good argument why maybe I get 10% or something like that. But when you're looking at a 20-year marriage or so, it's very unlikely that somebody's walking away with nothing.
Gotcha. Okay. So another question, and I think we have a blog about this on our website in regards to Massachusetts not being a community property state. Can you touch over that?
Sure. So there are only, I believe, 9 states that are community property states. The rest are what Massachusetts is an equitable division state. And the equitable, like I said, doesn't mean 50-50. And we don't necessarily differentiate from whose name property is in. So within community property, and again, I'm not licensed in a community property state, so I'm only speaking from what I've read and researched, not from actual practice. But my understanding of it is that if you put something into your joint name and you're getting divorced, each person has a right to 50% of that. So here, if you get a divorce, even if it's 50-50, it doesn't matter if it's in the wife's name, the husband's name, it doesn't matter whose name it's in. Whereas in a community property state, if it's only in my name and we're getting a divorce, the court could look at that as that's my property. If it's in our name individually or our name jointly, it's getting split. And the same thing with debt, with assets. And that's the difference, is it's more of black and white versus the kind of gray that we have. And anything that you're bringing in, even without a prenup, is typically going to be considered, if it's in your own name, that's your individual property rather than community property, which is during the marriage brought in by the couple. You can't quote me on any of that because, like I said, we are not a community property state. So I only go by my understanding of it, not my practice of it. But that's kind of the difference.
Gotcha. So now, I know you mentioned, marital assets is what you bring into the relationship, basically. So what are some examples? Obviously, the big ones is like, your house and your income and your 401k, retirement stuff. Now, with inheritance, I think that's a big question to get, because obviously it's like, well, if my mom leaves me $1,000 and $1,000.
Your mom did really well for herself.
Mom leaves me that kind of money, like, trying to think
Sure.
of.
I think I know where you're going. So let me try to start explaining, and then if there's any follow-up questions you can ask. So basically, inheritance is something a little bit different. It's still within Massachusetts going in that pot. So whether if you've received an inheritance, again, if you've received it before the marriage and it hasn't commingled, which we can talk about here, let me actually jot that down so I can go back to commingling. So if you had the inheritance prior to the marriage and it didn't actually touch anything, you have a good argument why that should be given to you without any portion of it or any other sort of division going to your spouse. But inheritance, if it really depends on the commingling aspect of it and when you receive it. You know, if you receive it, or even if you have an interest in it. So let's say somebody dies and it's going through probate. So you know you have something coming to you, but you're not sure what it is. Those are all things that people can go after. You know, again, let's say we're married and you have $1 million inheritance coming your way, but we're in the process of divorce. Now, I know you're going to be getting that $1 million. You know you're going to be getting that $1 million. Because you have an interest in it during the marriage, it actually goes into that pot. Now, again, it's up for debate. You know, there's a lot of factors that would go into whether or not I could get a share of it. You know, did we not put retirement money aside because we were going to be counting on that money coming in, you know, to utilize for our retirement? That might be one factor that looks at whether or not I should get any of it. So the best thing, and here's my legal tip of the day, I guess. The best thing to do is if you get an inheritance and you want to ensure that if anything goes wrong within your marriage, put it in a separate account in your own name and do not mix it with anything. Don't add money to it. If you take money out of it to use to something, it's probably gone at that point. And you're talking about it being, you know, able to be divided within a divorce, unless you enter into what's called a post-marital agreement or a post-nuptial agreement, which is kind of like a prenup, but done after the point of divorce or after the date of the marriage, which basically lays out that exact situation. So let's say you get your $1 million, we're still actually married, we haven't filed the divorce, you put it all aside, you take $500,000 out, you put it towards a house. That $500,000, you again might have an argument as to why you should get more than 50%, but you're looking at potentially that being a 50-50 division, whereas everything else that's set aside more than likely would still be looked at as, you know, that's her inheritance and be dealt with a little bit differently, where it might not be a 50-50 division or any division.
Okay. So going into that, like, let's say we get married and you know that I'm going to get a divorce. I mean, I'm going to get an inheritance later on in life. Like, it's going to come, but then we get divorced before I ever get it. And then I get it like 2 to 3 years after the divorce. Is there any like chance for coming back saying like,
not if I've waived that? And so that's what you kind of want. It's basically whether or not there's 100% certainty that you're getting it. So let's say your parents left you, or let's say they created an irrevocable trust. So that would be funds that you are definitively getting. They can't change it. If they've created any sort of revocable trust, or they just have a will that they can change at any point in time, that changes the characteristic of it. And you might know that it's guaranteed. I might know that it's guaranteed, but we got to wait for mom and dad to die. And that might not happen anytime soon. Or maybe before that happens, you guys have a big blowout and they say, screw you, Kayla, we're not giving you anything. So if there's still the possibility of them living, and the fact that they could change their will, and especially if it's within a will, if it's within an irrevocable trust, it's a little bit of a different argument. But if it's with anything that could potentially change in the future, the court generally will not really grant anything either way, because you're dealing with monopoly money. You're dealing with money that you may or may not have. Even if both parties are like, no, they're definitely going to give it to him, there's too many questions surrounding it.
Gotcha. Okay. And then you said you were going to come back to commingling.
Yeah, and I kind of did touch base on it. If this situation is arising, what I would say is if you know that you're going to be getting any sum of money, especially through an inheritance, sit down and talk with an attorney. Talk about what do I need to do to protect this money, and maybe you don't care. Maybe it's a situation where, if you guys are going to get a divorce, it's going to be 50-50 because that's what you've counted on, and there's going to be some sort of division. If that's the case, don't go through the expense. But if you're getting it and it's significant and you want to make sure that it's protected, whether it be protected for you or be protected for your children, then talk with an attorney and see what are the things I can do to have the best chance of this being assigned to me upon a divorce. And even if, it's an agreement that if we divorce, the money's going to go to the children upon them turning 21 or something like that. If the goal is to save it for the kids, you might be able to work something like that out. But I would advise everybody, I've done too many divorce cases where people think that it's their inheritance, so they're going to get it, but they haven't done the right things to protect themselves. So whenever whether it's just a cash or whether it's property or, whatever it might be that you're inheriting, talk to an attorney.
Now, can literally anything be considered marital assets if it's coming into the marriage, or is there a specific, like, are there things that you could bring to the marriage that would not be considered marital assets, or is it anything?
Well, so you have to remember that marital assets don't necessarily mean joint division. Mm-hmm. So again, think of it as that pot. It's marital property, which is different than who's getting what, or joint property. Joint property would be if we own a house and both our names are on it. That obviously is joint. If you've brought it into the marriage and there's nothing, again, no prenup segregating it, it's still going in the pot. It might be your property. You might keep that property. You might not have to give me any of the equity in that property, but it still goes into the marital pot and is considered marital property. And people get really confused about that. They're like, no, it was mine before. Whether it's still yours is up for debate. So,
gotcha. And
I prenup.
What is the best way to protect your marital assets, or any assets that you have going into a marriage, would be to get a prenup or a postnup if you're already married and you have things. But that's the best way, is to just have it in writing, and that protects you for anything when you're moving forward in a divorce.
Yeah.
Unfortunately, but for yourself sometimes.
Which, nobody wants to think about it. Nobody wants to get married thinking I'm going to get a divorce. But if you have things coming in, you want to be able to protect that, and again, maybe you don't. Maybe you're going to enter the marriage and you're looking at it as, I'm committing, and if they leave me tomorrow, if anything happens, I'm going to give them 50% of everything I brought in. Good for you. But if you want to make sure, and it also has to do with, if you died without a will, if you have a prenup, then your property doesn't automatically transfer due to, the laws. If you die without a will, it just gives you a little bit of added protection, especially if you have kids coming into a second or third, a multiple marriage. If you want to ensure that you're able to take care of them, then do them and yourselves a favor and get a prenup. Yeah. Just do it. And I know today's not about prenups, but it is important when we're talking, and so many people think I had this before I got married, so it's mine. If the other side agrees, okay, great, that's fine. But if not, then we have to look at, what is a judge going to look at? And it's going in the pot.
Exactly. And prenups are not hard. They're not hard to do. So, go into it getting one thinking you're never going to use it, and then it'll just be there if you need it. And that's
exactly. It's like car insurance. You hope you never get in an accident. Or life insurance.
You still need it to protect yourself in the event that it happens. So, any other ways to protect marital assets, or is that that's the biggest one, is to just detail things out in a prenup?
That's really the biggest one. I mean, if we want to get into creating trusts, things like that, that's obviously way more complex than what we're going to get into in a 30-minute Zoom that's almost over.
We do another segment on wills and trusts.
But if you're looking to protect yourself, and again, if you're going through a marriage looking, how do I need to protect myself? You might not necessarily be in the right marriage, but the other person should also understand that there's an open conversation, and it should be about making sure that each person is protected. So if you're looking at both parties being protected, that's a good attitude to have. If you're looking solely for yourself, that's a bad attitude, and you probably shouldn't be married in the first place. So that's not legal advice. That's just my own opinion, which I probably shouldn't give, but that's okay. Sorry. So your question was, are there any other ways? It's if you're talking about potentially getting divorced, the best way to protect your assets is a prenup or a postnup.
Gotcha. Okay. And if you have questions, talk to an attorney. If you have questions about your assets, is it counted? How do I go from here? Talk to an attorney. They can look at things and tell you. Yep. So anything else regarding marital assets?
Just, the things that a lot of people don't think about that can still be divided. Points, credit card points. I know, I love credit card points. I buy tons of things with credit card points because they're free. Those points can be divisible within a divorce, regardless of whose name they're in. So again, those are kind of the little things that even if the credit card is only in one person's name, potentially, the other person, again, unless there's a prenup, segregating it, the other person can go after those little perks. If there's timeshares, collections, people have artwork collections, that's something that could be an asset, but debt is as well. A lot of people don't pay attention to what their spouse is charging. Well, you should. You should be sitting down at least once a quarter to make sure that both parties understand what their financial situation is, because I've seen way too many couples get into a divorce and they're blown away by the fact, they owe $150,000 worth of debt they didn't even know they had. Now, whether or not that's a 50-50 division, it's about, what's equitable. But you might be on the hook for it. So know what your financial situation is within your marriage. Don't just say, oh, they do it all. Like, be proactive, understand what's going on in your life. And that's the best way to kind of prevent something moving forward.
Oh, that's another way to protect yourself.
There you go. Another way. Just educate yourself, know what's going on.
Be mindful of what's happening in your marriage, not just because. But
yep.
All right.
Because it's not about a lack of trust, it's about a partnership.
Exactly. And if it is a problem, then you have a bigger problem than just
try therapy.
Alrighty, well, I think this is a good overview in terms of marital assets to kind of understand. If you are out of state and you're watching us, remember that this is only for Massachusetts. Maybe we'll do another one for Rhode Island, because I know you mentioned that it is a little bit different there. Do you know how it's different in Rhode Island? Would you be able to kind of just?
We're kind of running on the edge of the half hour, but there are many similarities in Rhode Island. There's usually only very slight differences. So, we could either just focus on Rhode Island within another one, because I'm sure people in Massachusetts aren't going to care. So.
Alrighty, well, that was an overview for Massachusetts. And if you do have questions regarding your assets, or, if you want to do a prenuptial agreement, call our office. We do them. We also do postnuptial agreements. So if you're already married, you can still get them and still protect yourself moving forward.
We also do cohabitation agreements, which we didn't really discuss at all because we were talking about marital assets. But a lot of people now are either waiting to get married or just have no interest in getting married. A lot more people live together. They're buying houses together. Protect yourself, especially if you're buying a house with somebody and your name's not on the deed.
Yeah.
get a contract, do something to protect whatever it is that you're putting in, especially if you're not married, because the marriage at least gives an added protection. Again, if there's the prenup, typically, as long as it's done correctly, will overrule a lot of the laws. But marriage does provide both parties with a form of protection that's not there if you're not married.
Gotcha. Okay. Yeah, because I guess we wouldn't touch on that because that doesn't have to do.
That's a whole nother can of worms.
But it still kind of falls under those agreements to protect
Mhm.
yourself both financially and I guess emotionally moving
Yep.
forward if anything happens. So just be mindful, do your research, and if you have questions, call our office, and we can do a consult. You can talk to one of our attorneys and get some information to help make the best decision for yourself moving forward.
Yep.
So thank you so much for joining us.
Yep, thank you.
We'll be back next week with a special guest. So tune in next Tuesday.
I will be in Aruba. So it won't be me. All right. Thank you for watching. Talk to you soon.
Thanks. Bye.
Bye.